So we're going to keep Ms. Sprague, Mr. Vidal, and Ms. Vidal able to speak. The rest, everybody else is being muted.
Your Honor, before we proceed, I understand that is media here by telephone. I understand that an application proper procedure wasn't followed for media involvement in this matter, and I would ask that they be removed.
I'm not removing anybody. Court proceedings are open to the public. That is the national rule. We'll get to your application, but I'm not blocking anybody. We're not asking, he's not trying to photograph anything. If he wants to take the stuff, he can take it. I'm not removing anybody. If we get to issues that are sensitive to the child during the course of the morning, I may block people out, but not right now. This is J. Bradley Vidal versus Kristen Vidal, FM 14-404-23. The defendant is appearing pro se. Can I have plaintiff's counsel's appearance?
Good morning, Your Honor. Jessica Ragnar Sprague from the law firm of Jardine, Meisner, Stanley, Sprague, and Susser on behalf of the plaintiff, J. Bradley Vidal, who is also present on the screen.
Okay, we have a bunch of applications. As you all know, I'm kind of new to this proceeding, so I'm a little behind the curve still. So I may ask some questions that aren't directly related to the applications that I have in front of me. The ones that I think I'm dealing with are the most recent application that was filed on 3/14/25, an application from November 6th, 24, an application from November 5th, 24, and an application from 12/3/24. We're going to go in the order in which they were filed. So the first thing we're going to deal with is the 11/5/24 application, which was the defendant's application for a notice of motion in limine to exclude certain evidence. That means, Ms. Vidal, you get oral argument first on that application.
Good morning, Your Honor. Thank you so much. I apologize, I was a few minutes late, some technical errors this morning. I submitted the, I'm so sorry, judicial notice and a motion in limine at that exact time. I guess a couple of my filings may not have been done perfectly, but essentially they all applied to the status of our residency. Both myself and Mr. Vidal, not by my choice, but by order of the court when Mr. Vidal elected to sell our home in 2023. We've actually been residents of Florida for 18 months. And when I immediately came down here, I did not realize, I didn't know the law, I wasn't familiar with the Florida law, but it turns out, even though Judge Bogart ordered, unsupervised shared custody in January, there was a lot of ongoing legal, scheduling and so forth. But in any case, I didn't at that time realize that Florida has something called the clearinghouse statute, which basically address telehealth providers and so forth, and who can operate and who cannot operate within the state of Florida. I also found out that they have very strict regulations regarding the use of supervised visitation. I did not know prior to that time, and before Mr. Vidal moved down here, I believe Diane Wilmer gave us the recommendation of the Toby Center, which it turns out is unfortunately not licensed or certified, and haven't been for quite some time. So around that time in November, I did find out by visiting the Palm Beach County Clerk, where we both reside, where my child is enrolled in school and so forth, obviously the appropriate court to go to, and I tried to locate a supervision program. At that time, I was informed that Florida has very, very strict regulations for use of supervised visitation, in any case, whether it's voluntary like in our case or what have you. They do require a valid court order. There will be no vetted or licensed supervised center or provider that will cooperate without the instructions of the court, saying, who, when, why, so forth, some of the backstory. Then you pick your provider. But prior to that time, both litigants in every divorce and every custody case in Florida, there's a state-mandated 4-hour co-parenting class. Whether there's a restraining order in place, no matter the circumstances, everybody has to do it. If you want to live in Florida and use their supervisors, you have to complete this course. So when I found out about this in November, I did notify Judge Oliveira because at that time, we were still in a sort of stalling pattern. I haven't seen my son, I think it was 3 months at that time. It's now been 10 months. And I have repeatedly gone to the courts down here and, have tried to find out more and so forth. I've, attempted to conduct this matter via our family wizard, and I did actually enter several motions before the court. At that time, I wasn't 100%.
Let me interrupt you a second. Are we talking about your application to strike Mr. Coblin's report?
Yes, Your Honor.
Okay. All right. As long as that's what we're talking about, that's fine. Go ahead.
I'm so sorry. The motion in limine and the judicial notice were both submitted at that time. So I apologize. I meant to submit them both together as the appropriate motion. And to be honest, I've never filed a motion in limine. I had no idea what that meant. But essentially, it was just my attempt to not burden the court with more motions, like regular motions, and just provide the information to clarify where we were and what I needed. So my attempt in filing that limine was to strike Mr. Coblin, obviously for the reasons that have become much more clear recently. I sent Mr. Coblin a formal notice letting him know that he had been represented as possessing a medical doctorate before the court. He has constantly been referred to as a medical doctor, which he is not. As I understand it, he has like a 30-hour sort of certificate course from, he's a person in recovery from heroin for the last 40 years, and this is just like something that he does. So he doesn't have a very, very, impressive qualification. For whatever reason, I informed him when I did work with him and complete this, the examination. I said, Cliff, your paperwork isn't up to date. You're not in concert with the SAMHSA laws. I can't sign these disclosures until you update them, but I am happy to get updated forms for you, which he refused and said it would throw off his whole system. And I said, well, unfortunately, I cannot sign these papers. I'll speak with you. We can work with each other. That was up until he submitted a report without my notice. He did not involve me or anything to Ms. Sprague during a 7-month sabbatical from the court. And then, I dug in further at that point. I called the licensure board for the state of New Jersey, where he has his licensure for drug and alcohol evaluators. He very clearly was hired under the wrong understanding. And I have to believe that Mr. Coblin himself was aware, because I had recorded all of our exchanges, 6 hours. And there are doctors like Dr. Mark Singer, Dr. Marcy Pasternak, I believe. These are best interest evaluators who are educated and professional, and their expertise lies in best interest evaluations. Mr. Coblin is at minimum a drug and alcohol evaluator, which is what he was hired by the court to do. The court, they've been saying, oh, she's this and that for 3 years now. No evidence, no results to support it, none of any kind. But in any case, I participated with another drug and alcohol, which I also voluntarily did more hair follicles, SoberLink, everything. And when I found out that he wouldn't change his report, that he was trying to act as a best interest evaluator, which he knows that he's not, and I have him on testimony saying that. And then he sent an irregular report that was full of, he said that I had a relapse. He said that, all kinds of stuff. And I said, Cliff, sorry for any confusion, but number one, you're not allowed to send this report just to the other side. It's not dated. It's not signed. It wasn't conferred. It wasn't provided to me. All right, so you did. But in any case, we need to correct a couple of things, because as you know, and as the court is aware, in April of 2024, there was a 0.000 error reading on the SoberLink. Unfortunately, SoberLink's platform does something where if there's an error link, they'll send you a notice and say, hey, you have 15 minutes, go ahead and do a resubmission. This was a voluntary submission that I did very late in the evening. I fell asleep and didn't see it. So the next morning when I was informed that there was this error, I called SoberLink. They said, you know what, just go to a LabCorp or a Quest and get a 7-day alcohol test. That will supersede anything that we've tested for in this breathalyzer, which I did, which Cliff submitted, which the supervisor, so everyone's aware that that was a mistaken reader. There isn't any doubt about that. Unfortunately, when he wrote his report, whether it was for lack of memory or I'm not quite sure, he did complain that opposing counsel was very aggressive and harassed him considerably. And he seemed to be under the impression that he was being hired to conduct a psychological evaluation. I didn't correct him of that at the time because I didn't realize until listening to his notes later. But when I told him, listen, Cliff, you put errors in the report, you went outside of procedure, you won't update your medical disclosure forms as per New Jersey law statute and everything else. And, this is, and also, you're not allowed to, I didn't know at the time, you're not allowed to conduct this over Zoom in the state of Florida as per your licensure board and the clearinghouse statutes in the motion in limine. Long told me, F you, don't ever call me again. He cursed a lot, and that was the last time that we spoke. I have tried to contact him since. Only just recently I sent him, a legal memorandum just asking him to please submit something to the court to clarify his true credentials and to inform the court that he was not hired to conduct a psychological evaluation. He was not hired as a best interest evaluator, and that he had made a few mistakes by, I guess, the period of time from April to not very long, for 30 days when he, I guess, wrote this report. To be honest, I've never actually confirmed that he wrote it. It came from Ms. Sprague, and we have had multiple instances where, documents have been edited, law firms have had to contact the Attorney Ethics Board, and I really don't know whether that's his report at all. And at this point, he will not respond to calls. He won't do anything. So my entire limine motion, in addition to my judicial notice, was literally just the law surrounding this and seeking to, it's a two-party consent state in Florida. There was some really hideous picture of me squinting, which, they used as testimony and evidence that I was, doing crack or something. So there's that, there was split things that were incorrect, inadmissible, unallowable under the New Jersey Rules of Evidence, and on it went. So when you ask me about the limine, I'm sorry for this very long answer, but I guess everything else builds off of that. It's not admissible. It violates the rules of evidence. It violates professional conduct. It violates everything, not to mention telehealth laws in both New Jersey and Florida. And even though he's not a really great expert, he should be aware of his own licensure and what he's allowed to do and not to do. So the only complaints that he has in his report are inaccuracies reporting about April, where he received and gave me confirmation that he got the hair follicle results. So I'm not quite sure what happened there. If it maybe got edited after the fact, I don't know. And then also that he's not allowed to. He's not allowed to practice here. He's not a medical doctor, and it was misrepresented to the court that psychological evaluations through him was ordered, which it most certainly was not. So he didn't have any, even though I told him you can call Claire, you can call him when you want, you can call Brad. He didn't have any instructions from the court, let alone training, expertise, or qualifications to perform a best interest evaluation, which ranges in the neighborhood of $10,000, and he knows that at least. He got $1,500. He was hounded every day. It was very aggressive. And, at the end, Judge Bogart in August said, listen, if she sends us the last batch of AA, if she does the hair follicles, I consider it done enough. And, since that time, I have completed all these things over and over again, repeatedly. At this point, the only reason, I'm sorry, that answers your question. Hopefully, I don't want to take up all the court's time. I just one thing that I would really like to say is that today, my son has been withheld from me unnecessarily, unlawfully, to his detriment.
That's not this application. Ms. Sprague, go ahead.
Thank you, Your Honor. First, Your Honor, I have to address the jurisdiction. The jurisdiction was already denied in July of 2024, as well as in February 2025. New Jersey retains jurisdiction. Florida does not have jurisdiction. This order has already been entered. An appeal was attempted to have been filed by Ms. Vidal. That was denied by the appellate division. Jurisdiction remains in this court. There is only a temporary order for relocation. We have not had a hearing on that issue. The fact that Ms. Vidal continues to make arguments that somehow Florida law applies to this matter, it doesn't. This is a New Jersey case. Only New Jersey law applies. That, however, her entire start of her argument has nothing to do with the actual application that she filed. The application that she filed, that we are addressing now, was her application in limine, even though we had no trial date pending at that point in time, which is what an in limine motion is for. It's supposed to be submitted in conjunction with trial, was to exclude Mr. Copeland's report. Ms. Vidal gets it completely wrong. Mr. Copeland is not the court's expert. Mr. Copeland is our expert. He is the plaintiff's expert. He was not hired by the court. The court in September of 2023 entered an order allowing Mr. Vidal to obtain his own expert. He hired a different expert, an expert that Ms. Vidal refused to comply. There are multiple court orders requiring her to comply with the first expert that Mr. Vidal hired. Because she refused to comply, outright refused from because she will not go to this expert. So we hired a new expert, Your Honor. We hired Mr. Copeland. Mr. Copeland was hired to do our substance abuse evaluation. The only person that he's going to correspond with is me, because he's our expert, not Ms. Vidal. The report was provided to me as our expert. Once we received it and decided we were going to use it, that was submitted to the court in conjunction with an application. Unfortunately, he could not complete his report because she refused to comply with the expert, despite multiple court orders requiring her to comply with the expert. She refused to fill out intake forms. She refused to sign authorizations for Mr. Copeland to speak with even the supervisor. She refused to sign the authorization for him to speak with her treating provider. She refused to cooperate. And quite frankly, Your Honor, she violated law when she admitted on the record right now that she recorded every conversation with Mr. Copeland while she was in Florida and he was in New Jersey. That is a violation of the wiretapping law in Florida, which requires two-party consent. Mr. Copeland did not consent to that recording. Your Honor, he did not conduct a best interest evaluation. There is nothing within his report that says he was conducting a best interest evaluation. He was conducting a substance abuse evaluation. Now, if and when we get to the point of trial, he will be a witness. At this point in time, nothing is entered into evidence. We haven't actually had that hearing. He will be on the stand. He will give his testimony in conjunction with his report. That is proper procedure. There is no basis, no legal basis on which Ms. Vidal has presented to exclude this report at this point in time. This is an improper application. Now, quite frankly, she also asked for additional things in this application that she hasn't even addressed in her argument, Your Honor. I will briefly address. First was the Copeland's report. The next, Your Honor, is for Bragg's letter to Dr. Sufno. There is a letter from the time when the parties were married that Ms. Vidal had sent and signed authorizing her treating provider to communicate with him as her husband. She has sought to exclude that. She has provided legal basis to do that. We're not at the point of trial. If the court decides to exclude at a trial, that's the court's decision upon proper objection. But this is not a proper application. Additionally, Your Honor, she asked for objection to Sprague's photos and reference to an accident over 2 years ago. She is referencing her DWI that she had in March of 2022 with a school bus in the middle of the day with children on it at twice the legal limit. Your Honor, she's seeking to exclude the fact that she had a DWI in a case that has, for the most part, dealing with her substance abuse issues, her alcohol abuse, her cocaine abuse. Your Honor, Ms. Vidal has been an addict. She almost died twice from use of alcohol in 2022. That isn't even to mention that even after the temporary restraining order was entered where she assaulted Mr. Vidal, and then she had violated that restraining order the day after she got it, she had the DWI. She also went into detox at St. Clair's. She also went to an extended detox, and then they refused to ever comply with any recommendation. She did not even start soberly, AA, NA, anything, until she got put on PTI for violating the restraining order. She seeks to exclude substantial evidence regarding her addiction that is relevant and necessary to this case. She's the one that has the DWI. There is no basis to exclude that information. She seeks to exclude a photo. Wiretapping is not photographs. A photograph, a screenshot, quite frankly, a screenshot that the child took when he was on the call with her, is not something that can be excluded for wiretapping. Wiretapping is recording sound, not picture. The last request she has in this application is that, in of itself, an objection to the FaceTime image of myself that Ms. Sprague lied to the court about. There was no lies. It was a screenshot that had been taken. This is not a proper application. There is nothing within here that should be granted. In response, Your Honor, we did file a cross motion back at that time, and in that cross application, we had requested a denial of the motion in limine that was improperly filed, as well as counsel fees and costs in connection with that application for those remaining being held in trust.
This is a defendant's application to strike Mr. Kovlin's report from the record. Court is denying that the Kovlin is the plaintiff's expert, not a treatment doctor. 42 CFR is inapt to the issue. Kovlin's evaluation was ordered by the court, and according to the plaintiff, all it says is that Mr. Kovlin did not make formal recommendations due to defendant's failure to cooperate. Florida law cited by the defendant also does not apply here. Kovlin is not a telehealth provider. He's an evaluator. The rest can be dealt with in cross-examination if the plaintiff calls Mr. Kovlin as a witness. Regard to the second prayer, that a letter to Dr. Suckno that plaintiff submitted to the court is hearsay. That's true, it is hearsay, but that's not a basis for an application here. It's a basis for an application at the trial. And it's important, the letter wasn't provided in the paperwork, which is something that would have to be done. Third, the objection to Ms. Sprague's photos with regard to the accident that occurred. Ms. Sprague's argument is correct. It is relevant whether somebody has a DUI. Again, that's also a hearsay document, but for purposes of today, the court accepts the police report, and therefore I'm denying the application. The objection to the Facebook image, it wasn't provided to the court. The court can't deal with stuff that's not provided to it, so I'm denying that application without prejudice. On the notice of cross motion, the request that we deny the motion I just addressed, counsel fees and costs are denied without prejudice to final hearing. Next application is the November 6th application, which was filed by Ms. Sprague on behalf of the plaintiff. Go ahead, Ms. Sprague.
Thank you, Your Honor. Your Honor, we received an order on August 15th, 2024. We had filed a motion for reconsideration of a number of those issues that Judge Bogart then issued an order in October of 2024 that said, because I'm no longer the judge on this case, I am no longer going to address those issues. You have the right to go refile this before the new judge hearing. So essentially that is what it is, and it is dealing with a couple of those issues from the August 15th, 2024 order. Starting with discovery, Your Honor, we have requested the dismissal of the plaintiff's pleadings based upon her failure to respond to discovery. She has failed to respond to discovery. She continues to fail to respond to discovery. This is outlined in detail in our pleadings, Your Honor.
It is, Ms. Sprague, but I'm going to cut you short here. There were 2 rounds of discovery based on your paperwork. Ms. Rosanella, who was then the defendant's attorney, did answer some things. There were objections that were really inappropriate. It's my understanding that she then sent new responses to the discovery from the first round. You sent the second round. I don't think I received your actual propounded discovery on the second round. And so it's real hard for me to answer those issues with discovery because I don't know what it is that you requested as part of the second round and whether the court would even feel that it was appropriate discovery or something for which the court should dismiss somebody's pleadings or do any other remedy under the court rules. So tell me where I can find the second round of stuff that you actually propounded.
Sure. It's actually 3 rounds, Your Honor. There were 3 rounds of discovery in this matter. The first round of discovery was done in April of 2023, Your Honor. That was done when Ms. Vidal was being represented by Foster Fernandez. Those were done and completed by both sides in May of 2023. That was round number 1. Round number 2 came after the September 15th, 2023 order. Judge Bogart provided that each party could issue additional limited discovery demands. Those were to be propounded within a couple days. That was when Ms. Brusinello was hired. She got an extension to serve until October. We responded to ours. They did not respond to theirs other than to object to every single question. They did that in November of 2023. When they objected to everything, another motion was filed, which resulted in the December 22nd, 2023 order. That order required her to actually provide responses to those discovery demands and also allowed additional discovery demands to be propounded. They were
interrogatories or the request for documents?
I believe they're in there. Honor, just give me one moment. I can just find it. I know it's a lengthy application.
All right, I don't want to hold up the whole thing because you'll have to come back to that at a later point. But right now, I have a problem with that portion of your application because I don't think I have, and I tried to look through everything, and I may have missed because this file, every time there's a motion, it looks like there's 400 pages of exhibits. But even if you filed or propounded discovery that was not answered,
Yes.
are you not bound by Rule 4:23(5), which would require, if your application is correct, that it be dismissed without prejudice, and that you'd have to give her notice that she had time to comply and file the sanction fee, and only then could it be dismissed with prejudice.
Your Honor, first, I did find the exhibit, Your Honor. It's Exhibit HH.
I'll have to go back and look at it when we're done. Go ahead.
And Your Honor, we submitted this application under the other discovery rule, which provides that if somebody refuses to answer, one of the consequences is dismissal of their pleadings. I did not file under the Rule 4:23 portion of the rules. I filed under the rule, I believe it's 4:24, Your Honor.
That's not going to work. Because that's not the way, especially when we're dealing with a pro se litigant. I'm going to immediately jump to dismissing her pleadings. I'm not doing that. Go ahead. Go to your next application.
Your Honor, obviously that all relates back to the dismissal of her pleadings for her refusal to respond. We were requesting default. This matter has not progressed, and the reason it has not progressed is that Ms. Vidal refuses to comply with anything in this case, unfortunately.
Let's get to number 4. Your request to invalidate.
Deeming the defendant's request to invalidate the prenuptial agreement waived based upon her failure to comply with the court rule.
This is what I was talking about at the beginning of the proceeding this morning. She filed papers in August of 23, I think it was August 1st of 23, when she was represented by counsel Joseph Murphy, I think was the attorney. And attached to that was a report from a Mr. Lesnovich from Maryland. What happened to the Lesnovich report?
Your Honor, they had, in that application by Mr. Murphy, he had requested the ability to review, and they had actually hired a new expert, John Paul Osborne. They hired him, and they wanted him to review the original. I had the original sitting in my safe in my office. That was ordered on September 15th, 2023. The court ordered that her expert be permitted to review the original document. That original document, again, is sitting in my safe in my office. She was directed to do it. I sent numerous correspondences between September and November requesting a time for their expert to come to my office and review these documents. There were letters after letters after letters requesting that he come do this Mr. John Paul Osborne. Come December, we filed the application in November saying, if you're not going to set a date to come review this, then don't do it. December 22nd, 2023, the court orders that it be reviewed no later than January 26th, 2024. Mr. Osborne came to my office on January 24th, 2024 to review that document. No report has ever been provided by Ms. Vidal from her expert who reviewed the original documentation. It was directed to be done done by, I believe it was March 2024. It was never produced. There were multiple applications, and then Judge Bogart then addressed it, I believe, in May, and then again in August, saying she had to get it in within 45 days. She had to get that John Paul Osborne report in within 45 days. He was the expert who reviewed that original document. We still have not received that report. It still has not been produced or provided.
What happened to the Lesnovich report?
There's been nothing with that, Your Honor. I have no idea whether Ms. Vidal intends to call that person as a witness. Obviously, the document in and of itself is hearsay without testimony and cannot be entered into evidence without testimony. But that was never our understanding of who her expert was. Those reports kind of went out the window when they hired John Paul Osborne and said that he was reviewing the original document, and he was the expert who reviewed the original document. And then no report has ever been produced since then. Despite court orders requiring to do that. Going on to the next prayer for relief, Your Honor, Judge Bogart ordered on August 15th, 2024, that my client was to receive his remaining funds that are sitting in trust. Unfortunately, Ms. Vidal, even though that court order exists and required it to be released, has refused to provide her consent to Mr. Fahey for those funds to be released. Mr. Fahey is not comfortable releasing funds without a very specific order from the court stating what the amount is that is to be released to my client. So we are asking that his remaining 50% share be released to him along with the funds that she was required to pay him for her failure to sign over the insurance check, which was also part of the August 15th, 2024 order. So the combined total of those two, and we produced the accounting of that within our papers, is $187,227.35.
Go ahead, you're up to RMA.
Yes, Your Honor. There are remaining embryos sitting in RMA. My client will never give his consent for those embryos to ever be used. RMA has made it very clear that
these are frozen eggs that have been inseminated with his sperm?
Yes, Your Honor.
Why weren't they ordered destroyed back a year and a half ago when the first application was made?
I don't know, Your Honor. Your Honor, it was denied without prejudice. Ms. Vidal was ordered to pay for it. She has not paid for it. She has not paid for the storage, even though she
but I mean, the paying for it is like a separate issue. I mean, I don't understand when a couple has embryos, if they're getting divorced, why is this even, I don't understand why it's even an issue.
I don't understand it myself, Your Honor. They should be destroyed. They should be immediately destroyed so there is never any accident.
All right, go on to the next one. Go on to number 7.
Your Honor, we had asked for the defendant be ordered to resume payment for the supervised visitation. Obviously, this application has been pending for quite some time. She hasn't exercised her supervised parenting time since June of 2024 by her own choice. She has refused to do that. And in fact, there's multiple orders from Judge Oliveira directing her specifically to resume her supervised parenting time, and she has not done it. She was directed to even provide us with alternative options for supervisors. She has not done that either. She has chosen not to exercise any form of parenting time with JR. Unfortunately, she has the ability to have the supervised parenting time, and she won't do it. But at this point in time, based upon her actions, Ms. Vidal shouldn't be the one paying. It should be Ms. Vidal, the one paying for it. That she's the one making these decisions and refusing to comply with court orders. So we are asking that she be ordered.
Was it initially that they were sharing the cost of the supervised parenting?
No, initially she was paying for it 100%, Your Honor. So when it started in April of 2023, she paid for 100% of it. In February 2024, Judge Bogart switched it to Mr. Vidal paying for it. And then we now are in the situation that we're in.
Okay.
Number 8. Yes, Your Honor. We're requesting that all video and telephone communication between the child and the defendant be recorded through our Family Wizard app. Now, I will note that after this application was filed, it was in December when we appeared before Judge Oliveira. So after this application was filed, Judge Oliveira did state on the record that if there continue to be issues with who's saying what on these calls, that she would order it to be recorded, because this continues to remain a huge issue. Quite frankly, even within the past week, the defendant stated to the child, "Your father wanted me to tell you that I am going to see you in 2 weeks." My client didn't say that, and she's putting words into the child's head. She's also told the child, "I'm not seeing you because Dad's not doing what he's supposed to do." These are all violations of the court order and reasons that these calls really do need to be recorded, because she's making claims that he's doing stuff for him, which he's not, and he's making claims that she's doing stuff, which she is. So just to protect all parties involved, there is a mechanism through our family wizard, which these parties are already using, to record these calls, so there is no inconsistency, there is no he said, she said, there is a clear and consistent recording of what is going on. Now, there are significant concerns for the child with what the defendant is saying. Now, she is specifically violating the August 15th, 2024 order in discussing litigation with the child, discussing these things with the child, disparaging my client to the child, which is all a violation of the August 14th, 2024 order.
All right, I'm skipping past your request for fees and the issue of the ex parte communications. Ms. Vidal, you filed a cross motion, and of course you can respond to everything that Ms. Sprague just said with regard to the application itself.
Thank you, Your Honor. I appreciate it. I'm going to begin by apologizing that I did not finish law school, unfortunately, due to COVID and the birth of my son. So sometimes this is all a little bit, the verbiage and the reference of law is a little bit above, even the word propounded is a bit above my lexicon. But in any case, going originally, I believe, to the, the escrow. First of all, with the telehealth laws, and I'm sorry, what I wanted to say actually is that I have researched considerably how to conduct myself as a pro se person, and I am informed that the best way to deal with false allegations and constant misrepresentations is just to ignore them and not to give them credence. And I think the record speaks for itself. So if I don't address a couple of things, it's because I'm choosing not to play into this. But to go back and talk about the prenuptial agreement that they have tried to have dismissed since this began in 2022, that whole thing. Could Your Honor please explain to me, in November, well before his TRO, Mr. Bedell secretly filed for divorce, even before he tricked me into buying the house. But in any case, at that time, Ms. Sprague put things into the record. She filed for divorce and whatever else. And in those papers, which of course I didn't see until much later because it was a secret, there was an alleged prenuptial agreement, which obviously I did not sign. The drafting attorney, they tried to tell the court he was dead. He's not dead. His name is Raymond Londa. He was happy to testify. He let me record his audio.
To any discussion regarding what Mr. Londa may or may not said in objection to any of that being placed in the record, because number one, it would be hearsay, a violation of attorney-client privilege, and quite frankly, could leave Mr. Londa from having some very serious ethical issues if this continues.
So, may I proceed, Your Honor?
Yeah, you can. You both violate the rule that says that anything that's in a certification has to be something that you could testify that's evidential. So both of you, both sides, in terms of presenting certifications, have provided information that is hearsay. For example, we talked before about a police report. That's hearsay, and that's not something that should be in a certification. So I'm going to skip past that a little. Go ahead, ma'am, and try to focus on the actual applications.
Thank you, Your Honor. And my question for actually would help.
The first application was to find you in violation of litigants' rights. It deals with the issue of the discovery failures. So focus on that.
Thank you, Your Honor. So the discovery matters. I'm not quite sure what Ms. Sprague is talking about in any of this. I will tell you that Ms. Rustianello from Haber Law, I believe some questions were given.
The big question is, has Mr. Osborne today so that you can get your parenting issues resolved in the next 6 weeks to 8 weeks. But you need to get this moving. We can't just have trials that stay out there forever, because what happens is we wind up with motion practice where we have 400 pages coming in every 2 weeks. Court can't handle that. So are you going to call Mr. Lesnovich, and I can skip past this?
Yes, thank you, Your Honor. That's perfect. I appreciate that. May I also call Jerry Lewis and Kurt Baggett, the other 2 experts, or just Lesnovich? I mean, it's fine if it's just
Lesnovich is the only report that I saw when I flipped through the paperwork, and his seemed to be the one that, if you went to his exhibits, was not in that opinion. The others that I saw looked like they would not fly in court anyway. So I think you're kind of stuck with Lesnovich.
Oh, Lesnovich is great. He's the head of forensics for the Department of Treasury. Kurt Baggett actually testified in 2000.
Okay. We have a lot to do this morning. You've indicated you're going to call him. That's fine. Mr. Sprague will have an opportunity to depose him before our trial dates.
Excellent. Thank you, Your Honor. As per the RMA items,
why should they not be destroyed?
The reason for keeping them has and remains the medical purposes. I'm sure Your Honor is aware that there's been a lot of U.S. Supreme Court, arguments on this, and the reason is because these embryos provide potential solutions to future diseases and so forth for JR, specifically for myself. And even though Mr. Bedell says he would never do this and never do that, no one's asking him for anything. But, RMA has told us very specifically that until the final divorce decree is done, that, they cannot destroy them. And beyond that, I would hope that Mr. Bedell would be okay with keeping them, because they do provide a potential for, cancers and certain genetic things and so forth. And, the future's uncertain, but if we have them, we also have the placenta. That's in storage. All of these things are for JR. There's no reason.
You have not retained any expert as to all these reasons, have you?
I'm sorry. It's in all the paperwork.
Have you hired any experts that deal with all the issues that you just put on the record about the medical purposes for keeping embryos? Because you can't testify. Because you didn't testify, you're not qualified. And again, discovery's closed. So if we get to trial, you would not be able to produce anything. Your testimony would be suppressed because you're not an expert. You're not qualified to talk about it. So why would I not be allowing the embryos to be destroyed?
Your Honor, RMA will not destroy them until the final divorce decree, because of the very reasons that, no, I'm not an expert. I apologize. And I was never asked for that. I didn't know that I had to. But I'm happy to provide the paperwork, which is actually, I believe, already in the record. I'm not quite following here, like, what is evidence and what's not. I've never even heard of an embryo expert. But, can RMA or the lawyer that they hired or somebody that's familiar with this, or can I just enter Supreme Court findings or something, and essentially produce something to explain to the court why both the placenta and the embryos should remain intact? Is that okay?
Well, I will allow you a short period of time to provide a brief that has case law that has not been overturned that says that embryos should be kept. I'll give you 10 days to do that. If you don't do it, I'm going to order they be destroyed.
Thank you, Your Honor.
Go to the next one, the $187,000.
So, Your Honor, Mr. Bedell and I built a pool at our former marital residence. And at the time of the pool, I was under representation. I was not involved. Things were not shared with me. But I've later discovered that Mr. Bedell made me pay $400,000 for a $400,000 pool that we paid for when it was built. But when he kicked me out of the house without my clothes, car, health insurance, kids, everything, and I was evicted from my life, that was in 2022. I have not been, my world has been taken since then. I find out that several months after this, Mr. Bedell took out private unsecured loans for construction that was never done. And that's the money that he took that $400,000 for. And I've brought this up many, many times. Number one, the PMA is a complete fraud, which I will absolutely prove. And Mr. Bedell has not provided any receipts, any proof, anything. He's literally trying to take money that doesn't belong to him. It was $1.8 million in cash, and I'm supposed to come out with the only asset that I have in the whole world. He's taken the Florida house. He won't. This is outrageous. Mr. Bedell and I built a $20 million fortune, separate and apart from everything that he did. And to sit there and say that I signed, while in law school, I signed a contract that Helen Keller wouldn't sign is outrageous. It's not supported by evidence. It's not supported by contract law. That $168,000, all we need is somebody to do the math and the dates according to the CISs that have filed. I did not take out loans in 2023 in Brad's name. I didn't sign them. I didn't receive them. I don't know what he did with them, but it looks to me like he took those out so that he could pay himself back from this false statement before the court about pool loans that were taken out in 2020 and paid. I'm sorry, for a pool that was paid and we were swimming in by 2020. I mean, the amount of mischaracterization, it's above my pay grade. I don't know. I literally feel like I'm in like the Twilight Zone at some point. How this has gone by, I can't explain. I had attorneys every single time the money ran out. I spent $300,000 and now I'm by myself. But I'm thankful for that because it's at least allowed me to really get into the weeds and have access to everything and look at the subpoenas and the documents. His certifications don't match. And talking about interrogatories and discovery, Mr. Bedell was asked in his discovery question, is there one DNA? Yes, there's only one. There's never been one. We have so many versions of this document, the notary's never seen them. The things that were presented had no seals. There's ones with seals, there's ones without seals. There's pages with no signatures. The notary herself doesn't recognize them. Ms. Sprague swapped documents out from the deposition. She was contacted by Reed Smith. She failed to respond back. I have 3 experts. I passed a polygraph with Jerry Lewis of the New Jersey State Police. I had never seen this document in 2022 when it was filed. But skipping ahead, my son brings his phone, which is connected to Mr. Bedell's iCloud, and he's sitting there scrolling through, playing on his phone. I was like, hold on, baby, go back. There's like a bunch of practice signatures. We did an ex parte order to Judge Bogard, my attorney, Mr. Cinello, and said, Your Honor, we found a bunch of practice signatures. He's got extra documents. So they're claiming that they never entered these extras, that they never told anyone about, because no one apparently ever asked them if there's more. Now they're claiming that anything they entered in the record in the beginning is bupkis because no one ever asked them if they had. It's so ridiculous. I literally feel like this is like a bad comedy. If you enter something into the record and then claim that you've hidden everything else because you were worried that if you stand in valid evidence that's been asked for repeatedly, that it might get lost in cyberspace, I don't even know how to respond to that. So the pool loans, anything touching money or assets, all I'm asking for is somebody to get a calculator out with an accounting degree and just take a look and present it before the court. Whatever that person says, by all means, Your Honor. But at this juncture, Mr. Bedell has robbed me of every penny, every retirement account, every credit card, every single asset in my entire life. 43 years, I barely have the clothes on my back. He's taken everything, and now he's taken out false pool loans that for a pool that was already paid for and won't give any receipts. I remember, evidence law.
Go to the Our Family Wizard.
The Our Family Wizard. Quite frankly, Your Honor, I'm not. Our Family Wizard isn't even. You don't need to record it. Mr. Bedell's sitting there the whole time terrorizing my child, telling him, "Tell mommy to check my message," sending me dirty messages that are insulting and offensive. The Our Family Wizard app is beautiful because it says, every single time since its onset, he refuses to talk about co-parenting, to talk about anything. He just uses a mechanism to harass me. And now they want to record the only conversations that I get. I'm almost tempted to say go ahead because he never lets me answer the phone. Every single night my son is busy, occupied, doesn't call me back, and I get these horrific messages. The only reason I'm here today is for my son. I could give anything about anything else. My son is...
Anything you want to say about me releasing missing ex parte communications?
I don't even know what she's talking about, but no, of course, absolutely.
What they're indicating is that you sent communications to the court without copying them, and they want to see those communications.
I would love to see them too. The only ones that I'm aware of are the demands letter for the prosecutors who are investigating Mr. Bedell for.
So now I'm skipping to your notice of cross motion. You wanted me to prohibit the plaintiff from filing any more applications with regard to discovery.
Was that my motion?
Yeah, it was your notice of cross motion.
So, I'm sorry. So I asked the court to not allow any more evidence or something.
No, you asked that I block them from making any other requests for discovery motions. Is basically what you were asking me to do.
Well, it's on the table for us to conduct. When I lost my attorney, I didn't even know what interrogatories were. So if there's an option to go through the record and just discover stuff, I mean, I hope I'm not speaking wrong.
How far did you go in law school?
I didn't get to constitutional law. I have a year and a half left.
So you did a year and a half, and you didn't have civil procedure?
Yes, I did actually have the Federal Rules of Civil Procedure. I also had.
They didn't talk about discovery at all?
Well, I was 9 months pregnant for the first year of law school, so perhaps my brain was a little foggy. But in any case, I do remember, and I have researched. I mean, this has been an education in and of itself. I don't think anyone should go to law school until they go through their own litigation. It's insane the amount of data. But no, Your Honor, I promise you, I was left told $50,000 ran out. Even Judge Bogart attacked. It wasn't their fault. You know, they can't work for free. But with the 600, 800, 1,200 pages that come every single day. Even DeMarzo was like, what in the world is going on? Why do we have 200,000 pages?
Your third prayer on your cross motion was to sanction the plaintiff for cutting and pasting HIPAA-protected information from a sealed document in the body of a motion. You want to talk about that?
Yeah, so, you know.
First of all, did you provide that? Did you tell me where it was? Did you show me what you're talking about in your paperwork? Because I don't remember seeing it, and I looked through all your paperwork.
So I think the last motion she filed had a cut and paste. Dr. Figarelli, who conducted 5 psychiatric, drug and alcohol exams, you know, I guess I really would have less of a problem with her cutting and pasting if she didn't do it out of context. For example, he uses the term diagnostic impression to suggest that those are the things that the doctor's saying that I have. It's a protected sealed document as per the court. And now it's, you know, apparently, I don't know, on the record and available for everyone. She doesn't follow those rules, and I'm pretty sure she graduated the same school I went to. So, you know, she's not supposed to do that. And especially if someone's going to be editing what they do, then cutting and pasting it, so there's no context for the reader. But yes, I think that's sanctionable. She has violated every HIPAA right, any right that I have in my whole world. And after this divorce, I would like to go on with my life. She's talking about a school bus that I never touched. I almost died swerving. I take full responsibility. I pray and ask for forgiveness every single day. No children were harmed. The bus wasn't touched. The thing was dismissed. I didn't intox a lot, and I've never drank again. So this whole constant wanting to abuse me with falsifying medical records that she refuses to address or retract. You know, even Bogart said the crime fraud exception applies in this place because there's been so much rampant crime. It just goes on and on and on. I guess one rule that would be great is to use the law. Follow the law.
Okay. All right. Okay, thank you, ma'am. On the plaintiff's application, the first prayer was to find her in violation of litigants' rights, and I'm assuming that application was primarily because of failure to comply with discovery. I'm not finding her in violation of litigants' rights. With regard to the second prayer, dismissing her pleadings based on a failure to respond to discovery, I did indicate that I think the applicable rule would require that it be dismissed without prejudice, and I also indicated, and I was honest, that I couldn't find the propounded discovery, so I am going to look at that. So that prayer I'm going to have to look at after we're done with arguments today. The third was scheduled for default. I'm not doing that. I'm actually giving trial dates today. The fourth prayer was to deem a defendant's request to invalidate the prenuptial waive based on failure to comply with the court order deadlines. I'm going to allow her to call Mr. Lesnovich. We're going to allow Ms. Sprague to depose him within 30 days. sure that Mr. Lesnovich cooperates and appears for a deposition, or else I'll be blocking him too. You understand, Ms. Vidal?
Yes, Your Honor.
Okay. The next prayer was to release the $187,227.35. I am releasing that. Judge Bogart ordered that on August 15, 2024. Later on one of these other applications, I'm releasing some funds to the defendant as well to be able to get attorney's fees, probably over the objection of the plaintiff, but I'm going to do that because we need to level the playing field in this case. Directing the RMA to destroy remaining embryos, I'm giving the defendant 10 days to provide legal authority that they should be maintained. If they are not, the court's going to order that they be destroyed. 7, to require that she resume payment for the supervised parenting. The court's going to order that she resume the supervised parenting with the parties to share the cost. Ms. Sprague has been forthright telling me that initially it was one responsibility, then it was the other. I think under the circumstances of this case, it should be a shared responsibility. 9, releasing the missing ex-parte communications made by defendant to the court to the plaintiff, granting that the plaintiff may review the court file and make copies of any ex-parte communications not in his possession. 10, counsel fees and costs are all denied without prejudice to the final hearing, which we are going to have in May. On the notice of cross motion, dismissing his notice of motion we've already addressed, prohibiting him from filing the same requests with multiple judges on multiple occasions. There's been failure of discovery, and it's clear that there's been failure of discovery, and Ms. Sprague is doing the proper advocacy for her client in filing applications to get the discovery or have the pleadings dismissed, so there would be absolutely no reason for this court to block those types of applications. 3, sanctioning him for cutting and pasting the HIPAA-protected information from a sealed document into the body of the motion. When somebody makes an application like that, you have to provide the document that you're complaining about. It was not provided here, so I'm denying it without prejudice. I'm not supposed to be guessing as to what we're talking about. 4, sanctioning the plaintiff and finding him in contempt for repeated fraud upon the court and failure to redact the fraud despite numerous requests from the plaintiff over 24 months. It's denied without prejudice to the final hearing. The court can always make a determination at the final hearing with regard to that. The next one we have is the December 3rd, 24 application. This was also the defendant's application. Ma'am, it was your application. It was to address the non-existence of a valid order mandating supervised visitation. I'll hear from you.
Thank you, Your Honor. There has never been a mandate to do supervised visitation. Mr. Vidal was granted temporary physical custody November 4th, 2022, pending the outcome of the trial. I did not see or speak to my son for 6 months. We have been in Florida since June of 23. At the 6-month mark in April, I voluntarily, without anyone asking me, purchased SoberLink in good faith, and I didn't know anything about supervised visitation, but Judge Bogart handed me Diane Wilmer's business card. I called her and I said, I thought it'd be like a week or two, like just a reunification situation. I didn't think it could hurt, have an expert there, what have you. I did not know what was happening. I have never been able to get out of it. From the very beginning, this has just gotten more and more and more and more strict. I have never been found unfit, dangerous, neglectful, abusive. I have complied with you'll see the next motion that you're going to do, which is when Judge Oliveira reiterated Judge Bogart's August 15th final order. She came out and December 10th, a couple days after this, and said, you know what, the parties can come up with any agreement they want, co-parenting, whatever. You can do it. You don't need our permission. Just go. If that can't happen, which of course it can't happen when I'm dealing with Mr. Vidal, who refuses to do anything or even discuss it or go to the co-parenting class or anything whatsoever. I'm told if I show up at plays, soccer, doctor's visits, I will be arrested on spot. I've been forbidden from every single aspect of my child's life. And in December 3rd, I said, thank you so much, Your Honor. Here are all the things that Judge Bogart said. I'm back. I'm so
You
sorry.
have? I haven't seen them. I haven't seen one AA sign it. Have you provided your sponsors through AA?
I have provided everything to the court as per the request in AA. And Your Honor, I will be happy to send those to you. But I've also provided almost 3 years of sobriety, undisputed psychological evaluations. And they say that I don't do a clip, and that's I've done so many drugs, you know.
Let me interrupt. Because Mr. Copeland, in his report, which I was able to look at for the first time this morning because the sealed documents were only delivered late on Friday, indicates that he did not see your AA sign-ins, he did not see your sponsorship, that the sober links, although all the ones you took were negative, there were loads of them that were missing, that you had not done the 12-panel test, and you had not done the other possibility. I can't think of what it was right now.
Your Honor, that's what that.
The Sprague, what's the other one? 12-panel or
Hair follicle. I did all those, Your Honor.
or the hair follicle. Right, there you go. Go ahead.
I've done all of these, Your Honor. I've done them all. And I addressed Chris Coblin's report in the beginning.
Well, then
I've done them all.
Then that's the application that you should have made. You should have made the application with Exhibit A being all your AA sign-ins since you began, Exhibit B being who your sponsor was and how we could contact them, Exhibit C being your hair follicle test, the actual test and the results, and Exhibit D being the 12-panel. That's what you should have provided in the certification, as opposed to just making arguments that you complied. How is the court supposed to know unless they see it?
I apologize, Your Honor. They have been supplied. They are on the record. I have submitted all of these. All of the AA stuff went to Bogart and Brad. He gets live sober links, and then the other ones went ex parte to Oliveira. That was a motion I filed on December 3rd. Along with it, everything was sent. I think like 20 different test results, hair follicles, almost 3 years of sober links. Everything is there. I'm not asking this court to make any trial decisions or anything. I'm asking this court to uphold and enforce the orders of the court. That is the only thing I'm asking. The court has ordered immediate unsupervised visitation. Bogart ordered it, Oliveira ordered it, and they have failed to do it. In the meanwhile, they have failed to do anything that allows me to have supervised. I'm asking, Your Honor, today, the only thing I'm asking is for the court orders to be enforced. Unsupervised parenting time to be enforced as per August 15th, paragraph 12, December CMC, December 10th, a couple of days after this. I have given the court everything, and it's there, and I apologize, Your Honor, if you don't have it in front of you, if I did not load it properly, but it is all there, as God is my witness. Everything. Okay. And if Your Honor takes a look at the 17 pages of quotes from the orders, the 35 orders in this case, every single one, there's something that's alarmingly clear. Mrs. Goodell will never, ever have her parenting time withheld as a result of Coblin or an evaluation. Having said that, I have still done them all, and I have certainly provided irrefutable. Ms. Sprague's argument has been that LabCorp and Quest are unreliable labs. I don't know how to respond to that. This is rampant. My son hasn't seen me in 10 months. I'm asking the court, please, to enforce the orders of the court as they have been previously ordered going back to January of 2024. Then again in May of 24. Then again in August of 24. Then again in December of 24. And if I'm not mistaken, even the last 2 things that Judge Oliveira put out over and over again. If Mr. Goodell won't do the things that are needed and you can't work out, you don't need us. There's no reason for supervised visitation. The court has already ordered that she's done everything. Give her her kid. He won't do that. And then she said, you know what, you come back to me, Kristen, if he will not obey the orders and do the supervised until we can get in front of you today, which they put off since January 31st, put off. I've been 17 months stalling pattern from when Judge Bogart first ordered unsupervised immediately in January of 2024. This is
okay.
I'm asking the court to enforce the orders.
Okay.
Right.
I think I missed one on the last motion. There was the prayer I skipped requiring the defendant to resume payment for supervised parenting. I'm ordering that the parties share the cost of parenting going. Maybe I did address it. All right, go ahead, Ms. your response to her motion.
Your Honor, I'll start with my response to her motion. There is not a single order that says she is to have immediate unsupervised parenting time. Not one in this entire case. The closest she might get to that would be the January 26, 2024 order, when she had filed she had filed an order to show cause in which Mr. Vidal had not had the opportunity to respond, which says that in connection with the request for unsupervised parenting time, the request is denied without prejudice. It was still denied. It says, in addition in there, that it was expected that supervised parenting time would be temporary. However, she has never complied with the court orders to allow it to progress. And quite frankly, Your Honor, the last two orders dealing with this issue, last two substantive orders dealing with this issue are number one, the November 14th, 2024 issue, which specifically states, contrary to the arguments being made by the defendant, immediate shared custody of J.R. Vidal is denied without prejudice. It was denied, Your Honor. Her application was denied. And in fact, in that same application, she was ordered to immediately resume that supervised parenting time. And they provided us with an organization that they were supposed to use. However, unfortunately, that organization never responded to either one of these parties. I can't control that. I don't know why. But at the same time, Mr. Vidal was willing to go back to the previous supervisors. She still wouldn't go to those supervisors. And again, on December 10th, 2024, the case management order by Judge Oliveira requires her to continue with supervised visitation. And in fact, with regard to the supervised visitation, defendant may utilize alternative parenting time supervisors, defendant to provide a proposed parenting time supervisor to counsel for the plaintiff. I never received any proposals from the defendant, not one. The only thing we've ever received is demands that Mr. Vidal participate in some class in Florida, which has never been part of any court order, not one. And we've never received any proposal for any supervisor. She's refused to exercise her supervised parenting time. It's in a court order. She has supervised parenting time as per court order. She refuses to exercise it. That's not Mr. Vidal's fault. That's Ms. Vidal's fault.
Your notice of cross motion, restraining her from filing further notices of motion on custody and or parenting.
Your Honor, that was until she actually completes what she is required to complete, which includes the psychiatric evaluation that Judge Oliveira ordered on November 14th, 2024 and December 10th, 2024. Ms. Vidal has not complied. Specifically, the court picked one of the three proposed experts that Ms. Vidal had. The order says the court has considered submissions of proposed psychiatric evaluators. Defendant may fulfill the obligation to undergo a psychiatric evaluation by engaging Dr. Cynthia Lissick to perform the evaluation. She hasn't done it, Judge. She hasn't done what the court ordered. She hasn't produced her NAAA records. We've received none of the redacted copies. We've received no information in regards to that. She hasn't done it. Quite frankly, the last time we were on the record with Judge Oliveira said, the letter you sent to me that you didn't provide to counsel had none of the information that I requested you provide. You provided none of those records. That is specifically on the record, and if I have to get the transcript, I will, because that's what the judge said. She did not produce what she was ordered to produce. She has not complied with the court orders, and she in fact has relapsed. She relapsed in the summer of 2023. She purchased alcohol. It was on her record. She refused to take SoberLink during that time period. She in fact lied to the court and said she was hospitalized for poisoning when she wasn't. She later clarified that no, it's her live-in boyfriend who was poisoned and he was in the hospital, not her. But she lied to the court and said it was her, which is why she didn't take the SoberLink test, when in fact she was drinking during that time period. She also failed a SoberLink test in April of 2024
her application said to address the non-existence of a valid order mandating supervised visitation that has resulted from misrepresentation of procedural history and findings of fact and resulted in denial of the defendant's custodial rights. That did not match the proposed form of order, which requested that she be immediately permitted unsupervised parenting time with JR pursuant to January 26, 24 order. There's been a lot of history that has passed since then. As I indicated, I'm going to be trying the case in May. I'm denying it without prejudice until we get to that trial, and then we can get full information, full credibility, and we can make an informed decision. But based on what I have at this point, especially from what I see in the Colvin report, I have to deny it without prejudice. The court's responsibility is to protect children, and there's a lot of missing information, at least as far as I have reviewed the record to this point. Second part of the proposed order was that he be required to comply with the 12/22/23 and 1/26/24 orders and utilize our family wizard to coordinate parenting time, pickups and drop-offs, etc. On one hand, she was objecting to our family wizard. Here she's asking that it be in play, and the court's going to grant that part of the application. The third prayer on the order was to release monies from ESCO for litigation expenses. Neither the issues of our family wizard or release of the funds from ESCO was addressed in certifications. All that said, for reasons expressed elsewhere, primarily leveling the playing field, the court is going to release $20,000 to her to be used only for litigation expenses. She must keep a clear accounting of the legal and or expert fees with proof of professional invoices and payments, or the court will order her to repay the funds.
Your Honor, just for clarity, she has approximately $3,000 remaining in trust with Mr. Fahey. Is that coming from that share?
Objection, Your Honor. That's $40,000 I have remaining in trust. I'm sorry, I cannot.
It's coming from Mr. Fahey's escrow funds. And the reason why so far, and I'm repeating what I said before, that I'm denying without prejudice the issue of the parenting time is because I don't see the SoberLink, all the SoberLink information, all the AA information, the psychiatric evaluations, and there's a lot of history in this case. Not coming in late, but maybe if I had been at the beginning, I wouldn't have ordered all this. But now I've got all these court orders saying that there's potentially at least a problem. I've got to go with what I see as potentially a problem, so we'll have to wait until the trial. Trial dates, by the way, and we'll send you out a pretrial order, are May 8th, 9th, and then the week of May 19th. And we'll go over the pretrial order before we leave today, so that I am sure that the defendant understands exactly what we're doing.
Your Honor, can you just
Your Honor, I'm so sorry.
What?
Your Honor, all of the test results and the AA results in the SoberLink are in the file.
I already had all your argument. I'm not doing redoing oral argument. Ms. Sprague, what?
I'm just asking you, could you repeat those dates for me?
May 8 and 9, and then the week of the 19th. So 5 days in the week of the 19th. 19, 20, 21, 22, and 23. That's 7 days of trial, at least they are going forward right now.
Your Honor, are we directing the parties to all be in New Jersey for that trial?
Oh, it's also the 7th, too. May 7, 8, 9. Yes, everybody's got to be here. I'm not trying to doing the trial remotely.
Thank you, Your Honor.
On the notice of cross motion, deny the motion, I already addressed that. 2, restraining the defendant from following further notices of motion on custody or parenting. As noted, with regard to the opposite side, with regard to discovery, an application to restrain application should be entertained only in the most egregious circumstances. Though these parties no doubt believe they have reached or passed the threshold, the court does not find it has even approached that threshold based on cases that I've had. If it were to be done, it would have to go through the assignment judge, and then the court would review motions and determine if the other side needed to respond. But this case is not there. A party advocating for custody parenting time should rarely and only in the most extraordinary circumstances, be cut off from potential judicial remedy. So that prayer is denied. 3, finding her in violation of the litigant's rights is denied without prejudice to the trial. Counsel fees and costs denied without prejudice to the trial. There was another application that I missed. She filed one on January 14th to quash the subpoena on PPAC Gladstone. Ma'am, you want to be heard on that?
Yes, Your Honor. I've supplied all bank records, everything. I have nothing to hide. I had just finished a CIS. Mr. Bedell, I'm not quite sure why he's after them, to be honest. But I guess if I can get the documentation on the loans for the pool, I mean, he can have anything he wants. If I can get the ex parte order and the J.R. Stone and all the evidence that's been withheld and they're in contempt for, I'd love that.
Then subpoena whatever you need.
I have. It's been refused. They refuse to comply. They will not do it.
Well, then file a motion. What reason do I have to suppress a subpoena to PPAC Gladstone? Based on our rules of discovery, which are basically very liberal, and you allow almost anything unless it's going to be something that violates the attorney-client privilege or some other privilege or something like that. It's supposed to be wide open. Why would I block this?
Because Mr. Bedell won't provide any of the same himself. If he could please provide all of the documents from the house sale and the escrow account and the pool loan, he can have anything he wants.
With all due respect, that's not before me. The application before me is your prayer to quash the subpoena to PPAC Gladstone, which I'm denying. There's not even a proper notice of motion. She doesn't provide the subpoena which she seeks to quash. There have been prior subpoenas to the bank in this case, which were not a challenge when she had attorneys. There's no basis to seek to quash. The notice of cross motion to deny her motion is granted. Counsel fees, on that one, I'm granting $1,000.
Your Honor, is that to come out of her share from Mr. Fahey's account?
Yes.
Thank you.
And I will point out that the $1,000 actually makes her lucky in that regard because based on the attorney's certification of services, he's still paying more for an application that was denied than she has to pay for the fact that I find that it was a frivolous application. All right, we're up to the last one, 314-25 application by Ms. Sprague. It's the order to show cause. Go ahead, Ms. Sprague.
Thank you, Your Honor. Your Honor, we find ourselves in a situation where Ms. Bedell has been sharing the pleadings from this case as well as recordings from this case with media. They have been published on social media sources as well as the internet. Unfortunately, what she's been providing has been outright lies. While I understand that the First Amendment protects speech, it does not protect false speech. By way of example, Your Honor, she's made accusations that Mr. Bedell somehow purchased Judge Bogard's Florida condo for him, and then Judge Bogard was somehow failed to recuse himself for having that financial employment without providing any kind of proof whatsoever. She has also provided personal financial documentation.
Sorry, I have to object there. I never said anything about a sequester apartment. That was someone else, Ms. Sprague. I'm sorry. I've listened to you live for an hour now. No. You provided.
What is your evidentiary objection to what Ms. Sprague has said?
I'm going to refer to my motion. I don't control the media and the New York Times, Project Veritas, using both. This has gone national, and that's not me.
That's your argument in opposition. That's not an objection. Go ahead, Ms. Sprague.
Thank you. The only way any of these individuals has gotten this information is directly from Ms. Bedell. She is the one that could only supply this information. She is the one that's produced this information. She's the one that had her own podcast and sent this on the air. She is the one that is producing this information. She is the one that is exposing my client to harm, me to harm, the child to harm, Judge Bogart to harm, Judge Oliviera to harm. Because of her actions, she has made substantial and significant false accusations against the individuals involved in this case. She's provided those individuals that, quite frankly, convicted felons, someone who held somebody by gunpoint, somebody who kidnapped somebody who has been disbarred, somebody who has lost their license to practice social work by posing as a doctor. She is...
All right, let me interrupt you. order against somebody that hasn't been named a party?
Because they're media, and the court is well within its discretion as for the information that we provided, and the
You're asking me to have entities that are not before me remove things and suppress things that they're writing about. How do I do that if they haven't been named?
Because they're media, Your Honor, and the media is permitted to be restricted under AOC guidelines. The court is well within its authority to restrict media access, and quite frankly, the fact that
that's access. That's not suppressing things that they previously written and asking them to remove it.
Your Honor, it's false information.
Why don't you argue about the sealing the record issue? Let's hear what you have to say about that.
Yes, Your Honor. Your Honor, this record should be sealed for the sake of the plaintiff, for the sake of the child, for the sake of others involved, based upon the false information that the defendant has been providing to outside sources, outright false information that we can easily prove by the actual record and by documentation. We provided that within the certifications, Your Honor, that she is outright making false claims and providing these to people that is potentially causing harm. There is already an order in place, Your Honor, that restricts her from
let me ask you, what's your remedy? You tell me what you think what your remedy is, other than me blocking it. Isn't your remedy to sue them for libel?
Oh, Your Honor, that will be coming. Of course, that will be going against the defendant and every.
But isn't that the remedy? You're saying that they're making false.
But Your Honor, you can
First of all, you're saying that she conveyed all this stuff to them. I don't know that they haven't gone to the courthouse and tried to look at records. How do I know that? How do I know that it's all coming from her?
Your Honor, because she did a podcast herself. That information is all on her podcast herself, where she is.
So sue her for slander or libel. Why am I
she will, Your Honor. She will be sued for slander and libel. That will be coming down the pipeline. But Your Honor can restrict her from discussing this case with other parties. Your Honor can restrict her from discussing this with the media. Your Honor can restrict her from providing court documents and personal records. There is a published handwritten document of my client because of the information that she provided.
Don't we start with the premise that all court proceedings are open to the public? Isn't that what the court rules say? Isn't that what the American rule is that all court proceedings are open except for example, division cases, juvenile cases, cases specifically dealing with the issues regarding, in this case, JR, but that anything beyond that is wide open for the public? Isn't that the premise of our jurisprudence in this country?
Well, Your Honor, I believe that may be incorrect in saying that as of April 1st, tomorrow, when the New Jersey court rules are amended for this year, that will be coming out tomorrow, includes an amendment to the record for any family law case, which in all documents are sealed. They are not. We're dealing with a couple days worth of time, Your Honor. As of tomorrow, those documents are not going to be available to the public. That is a rule amendment that is coming down tomorrow.
What else you got?
Your Honor, we're talking about the best interest of the child. We're talking about the best interest of the plaintiff, as well as the others involved in this matter, based upon the falsities that the
medical professionals or therapists who will maintain confidentiality. Rule 5:3-2 permits the court to protect a portion of the proceedings that deals with the child and authorizes sealings in those cases. The court would not seal the entire record here. And you may be correct, I wasn't familiar with the rules coming out tomorrow, so it all may change tomorrow, but this is today. In addition, the plaintiff didn't identify exactly what he requests to be sealed because the court will not seal the entire record. For each aspect that plaintiff seeks sealed, he must demonstrate a good cause reason specifically not generally related to the child. That said, both parties are bound by statutes and rules and the Supreme Court edicts. There is a process to be able to record proceedings which neither party has undertaken. A violation by unauthorized recording is subject to up to 6 months incarceration or a $1,000 fine. It would appear that the defendant has violated this and shall cease and desist. Rule 1:38-2D excludes from public access case information statements, confidential litigant forms, information sheets, medical, psychological, and alcohol and drug dependency records, child parenting time plans, etc. It has all sorts of things that in that area the court rules are protected and not allowed to be disseminated. Order Foundation for Child Victims of Family Courts and Jill Jones Soderman to remove their article entitled The Unraveling of Justice in Vidal versus Vidal, et cetera, et cetera. I'm not doing that. The entity is not before us, and although Ms. Sprague argues she can certainly bring that to the appellate division, that I have a right to control media, I'm not doing that. That's not the way we do stuff in this country. There's a difference between redressing a private wrong or something which has occurred and is already printed and seeking to suppress publication in advance. If what has previously been provided is libelous, then remedies are available. This is not it. Same thing with the next part for Odyssey.com, Marianne Petrie and Slam the Gavel. Same rules apply to them. Same thing with the Family Court Circus and Richard Luthman. 3, prohibit the defendant from discussing parenting with the minor child. Other than saying to a child, Mom and Dad are getting a divorce, judges will decide certain issues, including custody and parenting. There should be no discussion with the child about anything that's going on in a courtroom or in papers that are submitted to the court. If I find there's a violation, somebody's going to be sanctioned severely. That's the order going forward. You can tell the child that there is a legal case where they're fighting over your divorce. That's it. Neither party should ever tell the child that another party is at fault regarding lack of parenting time. I think that's it. I'm going to send out...
Your Honor, there was a paragraph 4 in the order to show cause requesting her that she commence her psychiatric evaluation, but the court-appointed expert by a date certain, and if she failed to do so, suspending her FaceTime call.
Your Honor, I have completed brain SPECT imaging scans by 2 of the world's leading neurosurgeon behavioral experts, just actually accepted in a White House executive order. The gentleman specifically that just completed my brain scans and everything, I can't get Cynthia lipstick. She's in New Jersey. I'm here. She won't work with me. And it was not ordered by the court. Look at the December 10th CMC order. It says Kristen may utilize. Obviously, Judge Oliveira says, I can't do anything. I can't make her, I can't order her to do something. So, I've done every expert under the sun. And, Your Honor, I am going to follow this just so that you have it. And make sure I even just update it on the record because it's been entered so many times. All AA, all test results, all the brain scans. The expert that I have coming in here to show the organic neuroplasticity definitive status of my fine.
Okay, all right. You have been ordered to commence your psychiatric evaluation over and over. But that is not a reason for me to change the parenting time pending the trial dates. So I'm denying that application anyway. All right, so you have trial dates 7, 8, and 9, and then the week of the 19th in May. So before I just said 8 and 9, it's 7, 8, and 9. So you have 8 days of trial. Pre-trial order is going to go out today. I want to draw the parties' attention to specific things with regard to the pre-trial order. First, Ms. Sprague and Ms. Badal are supposed to attempt to agree on joint exhibits in advance of the hearing. Because what's going to happen, Ms. Badal, this is primarily for you, there's going to be 3 sets of exhibits. They're going to be joint exhibits. Those are things that you don't dispute should come into evidence. Those are things like all the court orders, case information statements, things in the court file there should be no dispute about. But there may be additional things that the two of you can agree should come in as a joint exhibit. So you have to talk to each other and agree. In addition, the parties are then to have their own exhibits. So plaintiff will have plaintiff's exhibits that are going to be marked P1, P2, etc. And defendant's going to have defendant's exhibits marked D1, D2, etc. All the exhibits have to be date stamped. That means that each exhibit has to be in numerical order, page by page. So you start with your first exhibit with number 1, and you just keep counting on each page, and it has to be marked that way so that when we are at trial, we're not fumbling to find things. We can all just turn to exhibit P7, date stamp 33. We all know exactly where it is. So that's what you have to do.
Sorry, thank you, Your Honor. Is that kind of like the appendix thing for like appeals? So just sort of organized and like you said, numerical, chronological, and listed with like an index and stuff. Is that the base stamping?
You don't have. I mean, you should have an index of the exhibits. You don't have to have an index of the base stamp. But I'm telling you that in addition to the index of the exhibits, each exhibit has to have base stamp numbers so we can find where somebody's referring to.
Thank you, Your Honor.
At least 10 days before trial, in the event parties intend to refer to depositions during their direct examinations of witnesses, the parties are to serve and file with the court a list of all proposed references to depositions. At least 10 days prior to trial, the parties is to serve and file with the court a list of all disputed issues. At least 10 days before trial, the parties are to submit trial briefs on any relevant law that the parties wish to bring to the attention of the court. So, Mr. Dahl, for you, you'll have a list of your disputed issues. Issue by issue, you have to address in your trial brief, telling me what the issue is, what your position is, and what law supports your position.
Thank you, Your Honor.
No later than April 26th, that's about 10 days before the first trial date, you're supposed to both provide me with updated case information statements with all the relevant attachments. And since April 15th is tax day, that means that you should have your 2024 taxes attached.
Your Honor, I don't believe that will be the case for Mr. Vidal because of his businesses. He is usually on extension till October. I don't believe he'll be able to do that.
Then he needs his 23 and to provide me with the extension that he files.
No problem, Your Honor.
10 days before trial, you also provide the court ex parte. That means that you don't serve it to the other side, a sealed proposal of what your settlement proposal is, your last best position. And the reason for that, Ms. Badal, is if the court finds something grossly different from what you have put in there, the court can shift attorney's fees. Same thing is going the other way. I just used you because I assume that you didn't know exactly what I was talking about. I will send out the orders with some supplemental statement of reasons by the end of the week. I'm going to need some time. It took me a long time to go through this stuff.
Well, I believe there was just one issue that you didn't address that I'd like to just get clarity on. The OFW, we had requested that all calls be recorded through OFW going forward. Is that being granted?
I do want them recorded until the
Thank you.
trial. Because I don't want more nonsense. And I would suggest, and I'm not stopping anybody, I'm suggesting that with 6 weeks or 5.5 weeks until trial, that nobody should be filing any more motions. Because primarily what I'm going to do, if I receive a motion between now and the trial date, I'm going to deny it without prejudice to the trial. So don't even bother.
That wouldn't include a motion in limine on the
That does not include eliminating motions.
Thank you.